Brianna, Janine, Joe, Tyler, and Andre are going to continue to talk the laws of HR. I'll first going to talk about an age discrimination case. Well, I'm actually going to talk about age and religion first. I'm going to talk about an age discrimination case. It's with Atchinson's Transportation Service. It's a company based out of South Carolina. The operations manager, we'll call him Tom, terminated Will because he found out that he was 75 years old, not 70 years old. He claimed the insurance policy did not allow drivers to drive past the age of 75. He also did this to another driver that he terminated also, and obviously he lied to those employees. The EEOC was able to prove that the company's insurance policy does not have any age restriction for coverage, which brings us to the Age Discrimination Employment Act. A quote that pertains to this case would be, employers commonly make assumptions about how long persons should work before retirement, including assumptions about their ability to work based solely on age, which was said by their attorney. The Age Discrimination Employment Act basically prohibits discrimination in hiring, promotions, wages, or termination of employment and layoffs. It protects individuals who are 40 years old or older against discrimination. One's ability to work is not always dependent on age. I'm going to talk now about religion. It's going to be a religious discrimination case. Here's a hostile comment that was said by a supervisor. He said, "I don't know why we don't just fill all of them tailheads." This was said to and about Adam Gomez. He's from the company Swift Aviation, and he was harassed by his supervisor for his religion. He was Palestinian. The quote is hostile. So this forced him to resign, which is known as the constructive discharge. This case violates Title VII of the Civil Rights Act of 1964. The EEOC filed a lawsuit. Swift Aviation is now banned permanently for any harassment based on religion. Employer and employee relationship will always be a battle of power to differentiate roles. So I'm also going to talk about another religious case. It's actually a religious social media experiment. It was conducted by Carnegie Mellon University. It was an experiment to study social media and hiring processes of companies. The researchers created 4,000 fake social media profiles on Facebook and LinkedIn. They learned that 10 to 33% of U.S. companies search social media profiles early in the hiring process. Christians were most likely to get a call back, which was 17%, while Muslims got a callback rate of 2%. This shows the social media plays a huge part in the recruiting process. It shows that discrimination can happen using technology. You never know what an employer is finding on Google or Facebook or any other site on the internet that they can use to eliminate you from consideration. Social media screening and profiling is fundamental discrimination. This shows that employers are utilizing social media because profiles reveal a degree of personal info that cannot be inferred from an interview or a resume. So, just going back to the social media concept, this can obviously happen to anybody, and it might eventually happen to me when I apply to a future job. And I think to prevent this, I think maybe deleting or deactivating your profile so employers can't look through your profile and not give you an equal opportunity of getting the job. And then I'm going to present for Anna.
Is that paused?
No. Okay, so I'm Brianna, and I'm going to talk about sex-based and race and color discrimination. One of the laws associated with sex-based and race color discrimination is Title VII of the Civil Rights Act of 1964, which forbids discrimination on the basis of sex in hiring, promoting, and firing. In final legislation, it included race, color, religion, sex, and national origin. This title created the EEOC, the Equal Opportunity Commission. I'm going to go on to sex-based discrimination is treating someone less unfavorably because of their sex, or treating someone less favorably because of his or her connection with an organization or group associated with people of a certain sex. Then one of the preventative things is the Civil Rights Act of 1991, which parties are now able to obtain jury trials, recover compensatory and punitive damages. This also codified disparate impact theory and discrimination, the discrimination motivation factor. One of the cases that I looked into was Wolf versus Tinder. Tinder is an app facilitated for dating and hookups. Whitney Wolf was the former VP of marketing at Tinder, and she sued Tinder because the CMO would call her things like a whore, slut, or a gold digger, and when she reported this to the CEO, Rad, he dismissed it as her being dramatic. When Wolf then resigned, and when she filed the suit, Martine, the CMO, then stepped down, and Tinder and Wolf settled for a little over $1 million. This relates to me and other women because this could eventually, or could potentially happen to me or other women in the workplace, and I hope that that doesn't happen. Then I'm going to talk about race, color discrimination. Like I said, the Title VII Act protects us from race or color discrimination. Race and color discrimination is being treated unfairly because of your race or color. An example of this is Tiffany and Company, the jewelry company. They have less than 1% African Americans in their management team. Their managers include 200 people, and only one of them is African American. Tiffany went under new management, and the new manager requested pictures of all of his group directors, and McClure is the African American group director. He had been there since 1993, and he never received a bad performance review until the senior manager requested pictures of all the group directors to become more acquainted. Once he received these pictures, McClure received his first negative evaluation. He was denied his annual raise, and he was put on warning for termination. McClure also received an anonymous letter stating that this other employee had heard the senior management say to a group of other managers that he couldn't believe that an African American was the face of Tiffany and Company. This is clearly discrimination, and he filed suit against Tiffany, and they also settled, and the amount wasn't said, but it didn't go any further in court. So over the summer, the Supreme Court ruled same-sex marriage legal nationwide, and Bruce Jenner made his transition to a woman, becoming Caitlyn Jenner, and this is important because he's in the public eye. These are huge events for the LGBT community as well as the country, and it's important that they feel that they can be themselves within the workplace. So these persons are also protected under Title VII. I used to work at Sam's Club, and there was a transgender there, and there was a manager that always referred to the transgender person as a he, she, or an effing tranny, and he recently filed suit against Walmart this week because he was fired last month. Harassment in the workplace exists. It is important that we have these protections. Title VII and the EEOC are a huge factor in trying to implement equal opportunity among the workplace, and I'm going to give it over to Janina.
Hi, I'm Janine. I'm going to be talking about Pregnancy Discrimination Act. This was basically created because there was a lot of discrimination going on towards pregnant women, and it was created to amend Title VII of the Civil Rights Act. This was a direct act from the General Electric Company versus Gilbert case, and it was really because they were caught paying expenses and benefits to people who were unable to work but weren't providing any benefits for multiple pregnant women. This was found not necessarily illegal under the Title VII because they were offering the same benefits to men and to women, and both men and women, if they suffer disabilities, everyone's going to be covered under the same plan. But because in the plan they only said pregnant women and non-pregnant persons, it wasn't necessarily putting all women in the pregnant category, because not all women are going to be becoming pregnant. So this wasn't technically sex discrimination. Because of this, they formed the Pregnancy Discrimination Act, and it was to cover women's rights and just be more specific. So what this act is really just to prevent the discrimination against pregnancy, childbirth, or anything related to that. Any companies with 15 employees or more need to give out benefits for anybody who's pregnant. And basically it should just be really treated as a disability. You can't forbid to give something to a pregnant woman, like promote them versus somebody who isn't pregnant. So like I said before, they have to be equal, just like it can't be looked at as more harsh or less harsh. And as long as they're able to perform their major job functions, then it shouldn't be a problem. Now for their maternity leave, if a pregnant woman gets sick and they leave work, when they need to come back right away, because your employer can't give you a predetermined time of when you have to come back. So because of this, they thought it was unfair. They created the Family and Medical Leave Act, and this was for any new mother during foster adoption surrogate. It basically allows all new mothers to have 12 weeks paid or unpaid leave time, and you must be eligible. Usually it's just being with the company for 12 months or longer. The health insurance plan, it's just to cover all your expenses when you're pregnant, childbirth, illnesses, or anything like that. The only thing it won't cover is abortions, unless the mom is in danger. So the case with Holiday Inn in Mississippi, they were sued by EEOC for the Pregnancy Discrimination Act. They interviewed a woman who they hired for the position, and she was highly eligible for it. But her first day at work, she told her manager that she was in her first trimester, and she later that night was fired and replaced with somebody who wasn't pregnant. So because they replaced her with somebody who was not in the protected class, it just made the case a little bit stronger, and it was just evident why she was fired, because in the beginning she was hired for being highly qualified. On the flip side, for fathers, there are only 15% of American companies that offer any type of leave for new fathers. Josh Luz was a CNN reporter who took a stand after his third child. He charged CNN for not giving enough leave time. They gave him 2 weeks paid leave, which is more than usual, but he looked at it as sex discrimination. So he sued CNN for that, and we live in a modernized world now, so most of the fathers are now doing a lot of roles that women would do at home that in the past they wouldn't be doing, so it's only right to give leave to men as well as women. So this could potentially affect me and any other woman in this classroom, because at some point, if we want a family, we shouldn't be penalized for that. We should look for alternatives, maybe working from home or extending leave, because 12 weeks is not enough time, including the healing time and creating the trust between the baby and the mother. So if we could maybe find something else, like working from home, because we live in such a technology world. I had a 5th grade teacher that stayed until one week before she had the baby, because she wanted as much leave time as she could get with her child, which is unhealthy. and we should really just extend the leave time. This is Joe.